Hello and welcome. You're watching The Social Network on NDTV 24/7. I'm Kajari Sen, and today we are talking about what has been the top trend on Twitter, and that is a Madras High Court judgment on a maintenance suit which came up in front of them. A couple who had not been married but had been in a long-term relationship, who had 2 children, and the judge did go ahead and decide in favor of maintenance. Now that in itself, not controversial. That is, of course, something which has been debated many times over. What we are going to talk about today is some of the other things that the judge had to say in the observations he made around the case, and that is about where marriage stands, how marriage is defined, and whether marriage should be linked to sex alone. Our discussion for today: sex, lies and maintenance, the Madras High Court verdict. Was it judicial overspeak? Joining us today on our panel in studio with me, Director of Partners for Law and Development, Madhumera, Amit Lakhani, activist for the Safe Family Foundation, and Tehseen Pulawala, activist, who's also going to be giving us his take on whether this should be taken further. Also joining us from the Chennai studio, Punkureli, a lawyer who's also gone through the judgment and can give us her take on what this means, particularly in the context of the Tamil legal system. Madhu, let me start with you first. Maintenance in and of itself, particularly given the fact that he was responding to the fact that the lower court had not given this woman maintenance because it was not a marriage, meant that this judge did have to talk about marriage. Did he go too far in talking about marriage?
Yes, he did. You see, the simple question before the judge was not something unusual. It has been adjudicated on many times before. The question was a common law marriage, or a marriage where you don't have legal evidence of being formally legally married, whether in that context a woman who's cohabited with a man is entitled to maintenance. Many times before, the courts have held that she is entitled to maintenance, and that is the law. So she asserted her right, and she got, so in this very judgment, the judge says 500 rupees is due to her. She's got 2 children with him. They've lived together for a long time under the same roof. They've projected themselves as a couple. So
as a married couple.
They
is what the judge seems to be implying.
They constitute a common law couple. Now, if you look at the judgment, there are many indicators of a common law marriage that the judge goes through. They've lived together. They both had the legal capacity to marry, in the sense they both were single. They've had children together. They've spent substantial time together as a couple. Now, it's just that beyond that single point, which was before the judge seemed to have gone all over the place beyond that, and it reflects a complete lack of the conceptual ability to talk about common law marriage. So reduces everything to sex, and I think that's the awkwardness that we are all sort of alarmed by and responding to. But the main point of the judgment is not controversial itself at all.
No, I think that needs to be stressed, because one of the reasons I think it is a top trend at the moment is because the sense that was got from that article which made it trend is that he is saying having sex once means that marriage is automatically assumed. Amit, let me throw this to you. You've seen parts of the judgment as well. Do you feel that this is in fact hugely open to misinterpretation?
This is hugely going to be misinterpreted, and it is, if such a thing becomes a law, it is hugely, it'll grossly be misused. And basically, live-in relationships in India are not legalized, and we don't have a proper definition of live-in relationships, as in the period, whether it is a one-day relationship, it is a 1-month relationship, or a few years relationship. So when the lawmakers are not clear about what kind of relationship it is, they are kind of giving the same status as marriage is not done actually.
Tehseen, of course, that is one of the massive loopholes. The Supreme Court actually very clear on the definition of live-in relationship, which makes it a little strange that a Madras High Court judge is not looking at the Supreme Court definition, but is in fact talking about marriage and non-marriage relationships in the same sentence.
First of all, nobody should comment on a judgment without reading it completely. I haven't read it completely, so it's improper to comment on it. yes, from what little observations have come on in the paper, that could be the interpretation of the journalist. But let me make it very clear to your viewers and to all the Twitterati out there that we are nowhere close to granting a one-night stand or a fling as a marriage status. We are nowhere close. The Supreme Court judgment on live-in is extremely clear, as well as on premarital sex. In the Lata Singh versus State of UP and the premarital sex in the Khushbu judgment, the Supreme Court is extremely liberal. It is extremely, it says that a woman who's an adult and is consenting can live in or be married to anybody, and premarital sex is not an offense except under adultery under section 497, if I'm
which of course has been made clear,
which has been very clear. So this this observation of the Honorable High Court will not stand any ground before the Supreme Court. And as ma'am said rightly, it is the main judgment that we need to look at, and that is in favor of the woman, which is in accordance to with the law of the land. So I don't think there is anything to be paranoid about it, and we are nowhere close to granting flings as a marital step.
I think it's not paranoia. I think it's a closer look at the kind of vocabulary that has been used, and it's a question of possibly attitudes towards what is defined under law. Let's go over to Punkureli, who in fact has read the judgment and therefore can take us over what the kind of language used in it is. Punkureli, we were talking about the language used not just on the maintenance issue, which, as all of us agree here, is not something which is up for debate. I mean, that is under the right of the law. We're talking about the repeated associations made in this judgment between sex and marriage.
Yeah, you're absolutely right. I agree with Ms. Madhu on the point that the maintenance issue is not even in question, and that's been decided comprehensively. But this judgment is appalling at so many levels when in the way it's dealt with the sexual relationship and its association with legitimizing a marriage, because it says that the sexual consummation is the central portion to the marriage in itself, and even otherwise legal marriage which has been solemnized according to all customary rites, etc., will be void or lapse. Mind you, that's the language that's used, void or lapse, if the couple find their conjugal rights has not been fulfilled. Now, this is opposed to the statute, it's opposed to the law laid down by the Supreme Court, and it could lead to a lot of confusion and chaos. That's my biggest concern. And non-consummation of the marriage is only a ground under Hindu law to make a marriage voidable. This turns it around completely, and this also seems to suggest that it goes beyond the Supreme Court judgment of Justice Karju on live-in relationships, where it says that the couple have to live together for a considerable period of time and all that. That has been made out from the facts of this case, but the other observations seem to suggest that all that is not necessary, and if an adult man and a woman just live together and have a sexual relationship, that's enough to call them married.